Recognizing that there are 5 members of the committee here, which according to procedures established in our first meeting constitutes a quorum, we will get started with the quorum that is here currently. For all of those members who were unable to make it to the first meeting, we want to welcome you to this meeting. Thank you very much for coming. In moving to the second item on the agenda, which is the minutes, I'd like to invite a motion for the deferral of those minutes, given that we would have met only Monday and they're not yet quite prepared.
Propose that the minutes, issue of the minutes be deferred, Madam Chair. Motion.
I second, Madam Chair.
Okay. Thank you. The third item on the agenda is matters arising from the minutes. I would propose that there are no matters arising as we have deferred those minutes. The fourth item on the agenda is oral submissions. For those members who were not present, we had established in procedures at our first meeting with regards to oral presentations that persons who had expressed an interest in presenting to us today orally, there were presentations that were written and some were oral. There were 5 requests for oral presentations for today. We have received notice that one of those persons will not be here. And so we can expect 4 oral presentations so far based on the information we have to date. What we agreed in the procedures on Monday at our first meeting is that each person would have the opportunity to present for about 10 minutes, and then there'll be 15 to 20 minutes of questions and answers that we can pose as a committee, and altogether no more than half hour. And, we can show some flexibility given reason in that regard. We had also agreed that we had also asked that Mr. Chesterfield Coppin, who would not have been named properly on the committee, would serve as a resource person, as he would have been the officer that was most intensely involved in the consultations with stakeholders in bringing this bill to the next level. And so I would ask the permission of the committee to permit Mr. Chesterfield Coppin to sit as a technical resource as part of this committee today. Are there any objections at this stage? Okay. With that said, I think we have been able to move with dispatch to the submissions. Based on the speed with which we get through these submissions today, the thinking, again, according to procedure, is this procedure we agreed, is that we would have heard the oral presentations in the morning, then we would break for lunch, and then after we would go through the written presentations with the intention by the end of the day of determining how those submissions would impact or might impact the bill, and what adjustments, if any, would need to be made as required. Are there any other? Yes, sir. It depends on how fast we get through the presentations. So some presentations may take the full 4 minutes. The intention is to cover all today. And just let me use this opportunity to give notice to that following the request that was made for some groups to be reached out to directly, that the Clerk of Parliament and the team did indeed reach out to those groups, and we are now understanding that there may be 2 additional submissions. So far, we have been notified that the Bar Association would also wish to make a submission, as well as the Bankers Association. And according to the procedures which we established on Monday, we said that we would extend that deadline until Thursday, meaning tomorrow, for those submissions. And then we will seek to hear those submissions if there is a request for oral presentations on Monday. And if there is no request for oral, then that we will then consider the written presentations on that day. Anything further? Okay. Well, without further ado, I would recommend that we now go to the consideration of oral submissions. And what we will do for ease, with your permission, of course, is to invite all of the presenters in and simply call them one at a time so that they can see the presentations of the others. Okay. Well, I wish to acknowledge the presence of those persons and organizations that have requested to make an oral presentation before this Joint Select Committee. We will simply call you in the order in which your submissions were received. And what we will ask is that as you are called, you take your seat directly opposite. Ensure that the green light is on so that we can hear your presentation. It will be a presentation from sitting. You have 10 minutes to make your presentation, with about a 15 to 20 minutes for questions and answers or questions and comments, I should say, from the Joint Select Committee. We want you to be aware that your presentation is being streamed live, and you may begin when you're ready. The very first person we would wish to call is Miss Cynthia Wiggins. When you come, kindly identify yourself and the organization, if one, you are representing.
Hi, good morning. My name is Cynthia Wiggins. I am here as a user of data, an individual, and a small business owner as well. Morning, everybody. So I can begin? Right. I would first like to thank, I would first like to thank Madam Chairman and the members of the Joint Select Committee for allowing the public to provide submission on the Data Protection Bill. Second, although I believe the bill is an important one, I also believe that the amendments may be necessary to ensure that it facilitates, one, the provision of a framework that allows companies to have the flexibility to target individuals gain a competitive advantage through the utilization of data and data analysis while ensuring the privacy of individuals. 2, consideration of the new methods in which data can be captured, generated, and analyzed, for example, through retail transaction, online methods, blockchain, AI, etc. 3, viewing the protection of data more so from the standpoint of the data use itself than from the classification of the activities and the tasks in the data process. For conciseness and clarity in the preceding paragraphs or discussion, my submission points will be addressed under 6 main headings, with either page or section references where required. The main headings are as follows: data and data elements, content, privacy and security, monitoring and compliance, costs, and others, where I believe the points were important but did not fit under any of the above. In relation to data and data elements, I believe the bill in most instances does not seem to take into consideration the nuances of online and transactional data or the issues that would accompany such data types. For example, on page 12, accessible records, I believe online transaction records do not technically fall within any of the record types listed. Page 16, sensitive personal data, or in data on page 13 does not speak to photographs, videos, comments, etc. that does not include personal purchase or does not include personal purchasing information. Page 79, R does not include transactional or online data. Page 18, 4.1c, this would limit social media or other business ability to utilize data as part of their competitive advantage. Page 25.1, the point speaks to deceiving or misleading of individuals. However, businesses often collect data for purposes other than what they propose and change the reason that they're collecting data. For example, Facebook, you are connecting with your friends, but however, they actually analyze the data to advertise, gain revenue, etc. It's not necessarily for malicious reasons, it's just the nature of the business. Number 2, under the same heading, online data by its very nature may be onerous to describe, making the registration requirement on page 60, 51.2.1c difficult to comply with. For example, metadata, timestamps information, for example, timestamp information, location, landing pages, etc. in general be difficult to describe, but may be captured for analysis reasons. Additionally, data capture requirements may change to assist with online visitor analysis as the need arises, which would potentially hinder the innovation of a business if notification regarding the description is required. Number 3, in the normal course of business, data can be collected and used for profit or as a tool to gain a competitive advantage. So consideration will have to be given to the following points. Page 25, EIA, data can be collected for profit in relation to social media. Page 33, 18, 1.4 could limit an organization's use of data modeling, algorithm, and profiling, which may be how the company ensures its competitive advantage. For example, social media, Facebook, Instagram, etc. Page 27, 10.1, to provide the logic for profiling methods used could impact on the company's competitive advantage. I don't see a reference to the sales and transaction of other data or other data regarding the sale of actually companies. So whether or not when you sell a company is the data that refers and relates to individuals, is that that may become part of the sale. Is that fine with, do they need to actually inform the tribunal, the commissioner or the tribunal? The definition of direct marketing on page 33.3 does not seem to take into consideration telemarketing or online marketing, since there, excuse me, since there are no restrictions specific to telemarketing or content marketing within the points on direct marketing. For example, where the company may initially call, and I've had this where I would have gotten a call from one of the telecommunication companies under the pretense that they were informing me of a service problem, and they started to upsell. That sometimes happen. I've had numerous calls at 7:30 in the night, which I complained about and told them to place me on a do not call list. But that, there are loopholes within our legislations, yes, that allow for such things, so it becomes difficult for an individual to actually say that this is a problem. Where individuals may be targeting within the content that does not seem as though it is an advertisement. So we often get things that are not classified as advertisements, and it may just seem as though it's a normal conversation or for BuzzFeed, et cetera, or YouTube, funny video, but really and truly it's an advertisement. So how do we classify those things, and what do we do about those things? Although part of the general data protection regulations for small business, the requirement to have data privacy officers as a separate employee seems, the general data protection regulation for small business, it seems as though the financial requirement will be a little bit onerous for small business to have a data privacy officer, page 74, page 75, page 76, and would hinder small businesses seeking to utilize data as a competitive advantage. Just a note, I believe that we don't use data as much as we can or should as a competitive advantage. There are bigger businesses that are trying to seek to do that. Telecommunications companies tend to do that. Financial companies, although they have the data, don't use it as much, but they more than likely should. Consent. Number one, there is a need to specify in the bill that consent needs to be explicitly given by opting in for an...
Ms. Wiggins, you do have 2 more minutes.
Yes, that's fine. For utilizing, transfer, or processing of the data. Therefore, consideration would have to be given to the following, to certain points. The bill should seek to specify that individuals must notify on accidental disclosure, disruption, or breaches, which I don't think is currently there. Where an individual is no longer a user or a customer, they should be able to ask for the removal of the data, providing that it's not historical records or there is no legal ramifications. And under monitoring and compliance in the bill, there seems, although there is no obligation to comply, there are loopholes which would allow individuals to circumvent the requirements. There is a need to specify time frame or frequency in which some of the activities should occur, page 77 and page 79. I want to speak a little bit with the last minutes that I probably have with the cost issues, which I think will come up for a lot of business owners. If there's a legal cost associated, either legal, administrative, or otherwise, with individuals requesting information or trying to ensure compliance via the tribunal or a court, it may become a deterrent for individuals. For example, on page 28.3, not sure a data subject should be made to pay a fee in retrieving information that the data collector should have as part of their general service and their general operational costs. For example, you go to a bank and you want something printed from your account, they're pressed in print, and that's about it, and you're charged $5. I can see that being a loophole for persons to place costs to things that they don't need to place costs to. Other issues, page 10, financial institutions may not fall under credit referencing agency according to the definition, but they also have information regarding credit standing. I will Take, for example, the Student Revolving Loan Fund that has on a number of occasions sent information to your sureties, only informing you that they will send information to your sureties, but they actually would have provided your sureties with your financial standing, technically. I see that as an issue. I'm not sure of the minutes I have, if I have any more minutes, but I'll stop here. I can always provide a written document as well.
Thank you very much, Ms. Wiggins, and we really would have appreciated having at least the written document ahead because it would have meant we could follow you more closely.
Yes.
So thank you very much. I think that was very comprehensive as you touched on a number of the areas which you thought you saw some loopholes there that you thought should be addressed, and that you saw some cost issues. You also needed some clarification on definitions and a number of other important contributions that you made there.
Yes.
Are there any questions from the committee at this point in time,
Or comments?
or comments?
Madam Chair, thank you. Thank you for your presentation, Ms. Wiggins. I dearly would love to get a copy of your
Yes,
notes.
that's fine.
If that's,
Right. Time constraints. I wouldn't want something that I hadn't proved properly out there, so it was just a time constraint issue. Yeah, that's fine. I'll send it. Yes, that's fine.
Madam Chair, just one question for Ms. Wiggins. Thank you very much for your presentation.
You're
You
welcome.
noted that you are a small business owner without giving the name of your business, but could you tell us the type of business you own?
Right, I'm in content marketing
Okay.
and social media advertisement, etc.
Thank you.
Yes, you're welcome.
Thank you very much. We'd simply ask that electronically you submit your presentation to the Clerk of Parliament as you would have your initial
Yeah, sure.
presentations. All right, thank you. I would like now to call Mr. S. Antonio Hollinsworth to present to the Joint Select Committee. By yourself and who you're representing, and then please continue as you're ready.
Good morning, Madam Chairman, members of the Joint Select Committee. First of all, my name is S. Antonio Hollinsworth. I represent myself personally, and I'm the founder of Beijing Digital Creations, Inc. We are a company that deals with conversational artificial intelligence and virtual reality content. I believe that you've received a copy of my written submission.
Yes, we did.
Right. What I'm about to say is to put everything that I would have written in context. This is a story of a Bajan who returned home to heal. His hands trembling, his body ill, a shell of a man who left Barbados 13 years ago. This Bajan returned at a time where jobs were scarce, and his 13 years of educational experience in mathematics meant little. He had to survive. So this industrious Bajan, like every other proud Bajan, used what he had to do what had to be done. He used his skill set, willpower, sweat, and tears to build a business from a piece of driftwood to a digital entity with global reach in less than a year, bootstrapped. No loan because he had nothing, no political affiliation. He's the average Bajan from a working class family who lives by modest means in Christchurch Village. in a Christchurch village. He was willing to work hard and build in a time when building was difficult and resources extremely scarce. That story is familiar to most small to medium enterprises that will be affected by this current version of the bill. They need to survive. The artist selling her art online, she needed to survive. The taxi driver hustling to collect one of his clients who called, he needed to survive. The homeowner who runs an Airbnb to make extra, she needed to survive. The 60-plus-year-old seamstress who collects measurements on persons, she needed to survive. The startups that are still in gestation, they need to survive. These may not have the resources for another specialist employee called a data privacy officer. They may not have the time or resources to go through a certification or registration process. It is already difficult enough to start or do business in Barbados, and this bill, in its current form, makes it harder for small to medium enterprises to be profitable when money is scarce. Worse yet, under this bill, to take a chance with non-compliance is not only the end of whatever small business you may have, but the tarnishing of your reputation by incarceration of 3 years. I do not think that the government has educated its constituents thoroughly enough to enforce such draconian measures. That cannot be the reward for entrepreneurs at this time when the country needs more entrepreneurs. Under this bill, the government has introduced penalties that create a hostile environment for the average Bajan to enjoy his property, his business, and his network that he has cultivated. In my most humble opinion, this treads uncomfortably close to the spirit of the Constitution, which may stymie the growth of small business enterprises due to fear of the increased liability. In my opinion, and others, the government should delay the implementation of penalties until the public is fully aware of and sensitized to the importance of data protection and the inherent responsibilities of a data controller. For your consideration, a suggested period of 3 years to prepare before penalties are incurred, and that penalties be scaled to be commensurate with the revenue of the data controller or the data processor. Also, we request that the registration and certification of the data controller be waived to reduce bureaucracy and also facilitate the proper execution of the duties of the commissioner. A middle ground where the privacy policy may be maintained in terms of security, according to Article 6 of the Electronic Transaction Act, and that only in the case where the data controller or data processor's data privacy policy is unreasonably inefficient, that a data privacy officer is required for oversight. Data privacy is of utmost importance, and I commend the government for such swift move to protect the interests of their constituents. However, to make it onerous on the average Bajan to start and operate a small to medium enterprise is not in keeping with the resounding mandate that the constituents of this great nation, in full confidence, entrusted to the custodian of the government. I thank you.
Thank you very much, sir. Are there any questions at this stage? And we reserve the right to ask you questions both on your oral presentation as well as the written submission that you would have made.
Through you, Madam Chair. Sir, I think your presentation was quite profound and understand the perspective where you're coming from in relation to the small business owner, and also as well the skill set which you bring to the table being a practitioner within the field. At the end of the day, however, the government is obliged to balance its obligations with regard to generating business while seeking to bring itself in a more compliant state, recognizing that information and data being the new currency, that there are several external and even internal pressures to make sure that relevant legislation is in place. Recognizing the need for that balance, how would you, and I've noted your suggestions with regard to delay of the implementation of the enforcement provision and as well as the other suggestions, but assuming you had a magic wand, this is a purely hypothetical, sir, but how would you, in an ideal world, what would be the mechanism that you would suggest that would allow the government to balance its obligations to ensure the legislative framework is in place to provide the protection of the data, as well as to still encourage and facilitate small businesses who, for better or worse, have to find themselves in a position whereby they're able to comply with these new requirements, but may not have the resources to do so?
Right. So suggestions on how small to medium enterprises might be able to meet the requirements, basically.
Meet the requirements, and this is an ideal world scenario, so you are not limited by any form of practicality. It's just that how they can meet the requirements, recognizing that the government does have an obligation to the same citizens with regard to the protection mechanisms that are being proposed in the legislation.
Thank you. I will deal within the realm of practicality, because within the realm of practicality, what is defined as data, according to this bill, goes beyond electronic. It implies written information that is filed in a filing cabinet. It implies information that may be stored in an app on a cell phone. It implies information that may be stored within a cell phone. And I am going to present a real world situation whereby I had a conversation recently with an individual who was running a small Airbnb. And I had to sit down and go through with her the importance of compliance, that she should encrypt her phone, that she should lock the app. These are things that I may know because of my skill set, but the average Bajan may not know. I would not be willing to bet, because this is not the place for that, but most Bajans that have, or most individuals that may have the latest smartphone may not know or may not be aware that that phone has passive listening, waiting for someone to say a key phrase. And they may not have trained it to recognize their own voice. So that if you're going to bring a bill into play that essentially could make every citizen a data controller, then the necessary sensitization should occur before there is any debate. The fact that there are so few of us here to represent orally is an indication of how many people don't understand the 104 pages and the implications of that bill. So in terms of the practical application, the government should not place into legislation any bill that becomes an absurdity because you can't enforce it. So I would go with a systematic education of the public on how important data is, the value of their data, how they can protect their data. I am just going to ask the question, if I may, how many members in this room use two-factor authentication? And that's an indication. There are lots of Barbadians that do not know what two-factor authentication is. And they may just be people trying to make a living. They would have lost a job. They might have just been laid off, trying to find a way to make a living. And along comes this bill that requires them to register. And my concern is that it bears very much similarity with Jamaican Act, which requires registration and annual registration, which is not clarified in this bill. So for me, the average Barbadian, seeing that I must register as a data controller, and in that registration there are fees that the commissioner may impose, and those fees may be annual, essentially that's a tax.
Just one follow-up question, Madam Chair. If you were able then to suggest a delineation between the average person with a smartphone running an Airbnb was the example that you gave, and the interpretation as to whether that would fall under this regime will be determined. What level do you think the test, what level do you think this legislation should apply for? In other words, do you believe there should be some prescription as to amount of revenue? Do there be some type of prescription as to specific industries? Because you will note that there are specific areas which are excluded.
Yes, I know.
There are specific areas which are excluded.
Yes, I noted.
So then, of course, that then raises the implication as to what is included. And would you be able to suggest then, if we don't want to catch everyone in this net, what areas perhaps the government should be trying to focus on to be clear as that this legislation should explicitly affect?
Thank you for the question. Well, maybe we might want to start at the General Data Protection Regulation. It starts off speaking and addressing data controllers on a large scale. It's repeated on a large scale. Of course, that's relative to what is large. The European Union is much larger than Barbados, so large for the European Union might not be large for Barbados. So what I would recommend is that you look at you look at the annual revenue, right? And also you look at the impact that a data breach may have. Because if I have 10 telephone numbers or 10 clients, a data breach of that magnitude could be significant to them in terms of a civil situation, but not necessarily to the extent that they incur $500,000 and 3 years in prison. However, a large telecom company that may be running data for all of Barbados, a breach in that magnitude is a significant breach. Or if the state has a breach, that's a significant breach. Would that be required to be made public? One of the things that I would recommend that you also consider is that while you have a Data Privacy Protection Act, that you also have within the legislation or in another bill, a Freedom of Information Act, if one doesn't exist. Because if I'm surrendering my data to the government of Barbados, let's say TAMIS, the TAMIS privacy policy is woefully inadequate. Woefully inadequate. And I would like to know that if there is any breach that has occurred, that the public authority is held to notify the public that a breach has occurred.
No further questions. Thank you, sir. No further questions for me, Madam Chair.
Any other questions from the committee? Okay.
Thank you, Madam Chair. This is more a comment. When we had our closed session, we talked about the penalties, 3 years in prison and 500,000, and it was my understanding, and I'm open to correction here, that that's really a question of presentation, legal presentation, but any judge would have the discretion to do some of the things you're talking about, recognize the scale of the breach, the context of the breach, and so on. But I wonder if either you, Madam Chair, or Ms. Bell could just lend some color to that, because I'd hate to give you misinformation, but I think discretion is built into that. And I know that from your presentation and the way you've written and oral, the way you have talked to it, that it's of concern. But I believe that is recognized implicitly.
I'm going to ask Ms. Sean Bell, who is the senior parliamentary counsel who would have worked on the drafting of this bill, to respond to that comment.
Thank you. Chair, through you, just to speak to how penalty regimes usually work in Barbados, by reference to the Interpretation Act, Chapter 1. So when you speak to penalties, they are expressed at their maximum. So when you see $500,000 and then 3 years in prison, that is the maximum that the judge can impose for the particular offense that is identified. However, the judge would have a discretion to impose zero or no penalty to the maximum threshold that is set out in the legislation. Within that discretion, then the judge would then look at the circumstances of the case and then consider the seriousness of the infraction, any mitigating factors, before he would impose that penalty. So what needs to be recognized is that it would not be a fixed penalty as I see certain persons interpreting it, but more that it is an expression of a maximum penalty. I'm sorry, the maximum of that penalty.
May I respond?
Sure.
Yes. I gather, I understand what you're saying. Again, looking at it from a small business approach, the discretion of a judge could be $1, could be $10, could be $100. Legal fees to a small business can be the entire revenue of that small business for a month.
Chair, through you, just to say that when you are going through civil proceedings, the costs, if it is that you are then the party that is, I suppose, it falls in favor of, that you will be compensated by the other person. So those are facilities that are provided for by the Supreme Court rules. Those are things that are provided for. I do appreciate that there would be costs in starting civil proceedings, but or things like that. But there are provisions for that. Additionally, I also need to point out that according to the GDPR, you must take these breaches seriously, and so the state is under a mandate to make sure that they impose penalties that are sufficiently of notice to the public that it is serious. So in that, with that in mind, that is why the penalties appear in that form. So I just wanted to speak to that.
May I respond? Thank you for your submission. So based on what you've just said, I appreciate the benefit that would come for a small to medium enterprise that may be taken to court if they've sufficiently justified what has gone on. But in so doing, you've also opened up the door where a large entity who might have been in breach may be able to have all the legal machinations to work against a private citizen, whereby the private citizen loses the case.
Chair, through you, just to say, there was some submissions in relation to liability insurance and so on. So the question is whether there's actually that development for in the insurance industry for covering the potential liability that you may incur. Now that part is something that would need to develop maybe outside the sphere of the of this legislation, because for instance, like with attorneys, they have to, if they're, I think that service providers, they're required to get insurance set up to cover such things where they may find themselves liable for certain actions or infractions of legislation. And that requirement works throughout certain industries or professions. So I'm just making that observation.
I believe your time is up now. Thank you very much for your presentation and your contribution. And thank you especially too for your comment about public education as we move forward. That certainly is a significant part of the work that has to be done in preparing the country for this, the implementation of this particular act, of this
Thank you,
bill,
Madam Chair.
once it becomes an act.
Thank you for the opportunity.
The third presenter I'd like to invite is Mr. Barlett Morgan, who's representing Lex Caribbean. Please take this opportunity, sir, to make any corrections with regards to either your name or the organization you represent for the record.
Thank you, Minister. Good morning, Senators, members of Parliament, to the clerks present. First of all, I think thank you very much for this opportunity. I think it's a very positive signal as to the state of our democracy when we can allow persons, members, citizens all, to have some sort of input into important legislative developments like this. I don't know if clarification is the word, but I am here ostensibly in a personal capacity, and with perhaps good reason that I can get into later. But to the extent that I have 10 minutes to make my submissions, I would much prefer to sort of dive right in, and then we can perhaps deal with those other matters later. Now, I must say, just in the way of framing, that I think it's clearly high time that we got about the business of passing legislation like this. And I don't say that in the whimsical sense that, well, we always thought it was a good idea and now we've gotten around to it. But in the perhaps a more legalistic sense, which is that we have past due obligations to get this ball rolling. And I say that, among other things, with reference to our obligations under the Economic Partnership Agreement, which we have signed on to in 2008. I refer to that one specifically because among the hundreds of articles that we agreed to, when you read almost to the bottom of it, one of the primary things was that we would pass data protection, comprehensive data protection legislation within 7 years. Now, we signed on to that in 2008. And so, literally, we are past due on a very serious international obligation, as it were, under the EPA to pass this legislation. Now, the other reason why I mentioned that is because it flows into my first, I think, set of submissions. Now, to the extent I have 10 minutes, I suspect I may not get past the first set. And so I'll get to the point of it really quickly. Therefore, to my mind, big fish issue that, to my mind, this committee needs to be mindful of. I had a look at the, I think it's called the order paper this morning, and I note that it says that the purpose is really to consider the legislation and the degree to which, when passed, it will allow, it will allow for the protection of personal data while, allowing for transparency and accountability. And so I'm mindful of that in my comments. And so, to my mind, the major big fish that we need to tackle is the whole question of the independence of the regulator, which is the Data Privacy Commissioner. That is the first thing that jumps out at me on reading this latest iteration of the bill. The other thing is the question of compensation for data subjects. Thirdly, the framework for the Data Commissioner to actually audit data controllers and processors. That framework might need some rejigging. And so, in the main, what I want to start off with, and also a point which was addressed earlier, so I was thinking I'm not mentioning it, but is the whole question of the implementation periods and the timelines for implementation. I think those are perhaps the four biggest ones. So to start off with the whole question of independence, a part of why I would have mentioned the EPA was that in Article 197, I believe, it obligates us to not just implement a regulator for a data protection regime, but that the regulator has to be independent. And so it can't simply be just a sort of, a spawn of the government and taking directions from the government in the usual course of things. It has to operate in a truly independent sense. Now, on review of this draft, I note that even though there are many functions and listed on what the data commissioner ought to do, there's nothing that speaks in detail to any sort of staffing or HR type independence in terms of their ability to impact who is selected, how many persons are selected, so on. There is no sort of budgetary sort of independence that's outlined there. And so effectively, you have a regulator who will be, in a real sense, beholden to the minister that he will report to. And to the extent that this bill purports to have a regime that also encompasses the government and government agencies and so on, I'm hard-pressed to see in a situation where, with all of those factors and also no security of tenure, that a data commissioner would readily and gladly step into a government agency to audit them and to turn up negative findings. And so, to my mind, if we are to consider this in the context of accountability and transparency and a regime that is in the main effective, unless that's tackled and those issues are tackled, then I think it's quite likely that we may end up with a regime that looks really good on paper and it looks good to our international partners, but in terms of actually protecting the data-related rights of Barbadians and persons in Barbados, we may not be setting up ourselves to actually achieve that in a real sense. Now, I can perhaps go into more detail, but given the time constraints, I'll move on to the whole question of compensation. Now, if we see this purely in the context of incentives and just human nature, if this act is set up to protect the rights of data subjects, persons in Barbados who are data subjects, but there's no mechanism in the act for data subjects to be compensated when their rights are breached, I'm hard-pressed to imagine that very many persons would actually go about the hassle of seeking to enforce or to vindicate their rights pursuant to this bill as drafted. And I say that, by the way, to know that, if you look at the legislation that's considered, the gold standard nowadays, the GDPR, they have that right and it's expressly and clearly stated. If we look at even the prior draft of this very bill, it had that right to compensation. And so I would suggest that unless that is in place, again, we're lessening the likelihood that this bill, when passed into law, will actually meet the test that we've set out for it. Now, the other question that I think requires some attention is the whole sort of auditing framework that's present in the bill. Now, as it stands right now, as I read the bill, it's a process whereby, in effect, yes, you can give an assessment notice, but you can't actually go in to assess the data controller or the processor until you've gotten a warrant from the courts. Now, that's going to be a very time-consuming and expensive process for the data commissioner itself. With whatever budget they have, however limited it may be, that's more expense and time incurred just to simply get a warrant to go and investigate, essentially. Now, it would seem to me that, again, in line with prevailing best practices globally, that we ought to have within the bill some provision whereby there can be, at the very least, what I would refer to as a consensual audit process. So the data commissioner, for whatever reason, says, I would like to investigate you, or even perhaps of your own volition as a data controller, you think your systems are up to muster, and so you'd want to ensure that they pass the tests outlined in the bill, and so you can invite the data commissioner in to have a look. And so there needs to be some mechanism to allow for that process, because otherwise this becomes an unnecessarily expensive process for even the data commissioner himself to partake in. Now, again, I'm not sure how as time goes, I literally have 2 minutes left, and so I'll move right on to the whole question of the grace period for implementation. And this to me is a practical issue more than anything else. If we were to quickly pass the bill into law as an act in its entirety, then by default, most Barbadian entities would be in breach. And that's the simple reality of it. And so having a time frame within which persons can get their houses in order, I think is just a practical thing that we ought to be mindful of and to legislate for. And also there's the other added benefit, which is it allows the data commissioner to begin his work of awareness, because that's one of his obligations. And so it would seem to me that perhaps the best approach may be to pass those sections of the bill into law that enliven or give power to the data commissioner to first of all exist, so that he can get about the business of sensitization and awareness, and also putting in practical mechanisms in place for his own office to operate first before we actually get about the business of enforcing the act. Now, I just want to quickly run past that in my last minute, to outline some other matters which I think...
You're very creative with your time, sir. That's okay.
If my time is up, then that's fine, ma'am. Yes. So, just very quickly, there are a number of other things, and first of all, I should perhaps apologize, because as I understood the invitation, it was sort of present orally, or otherwise, if you're not minded to do so, then do written submissions. I'd be happy to put together written submissions to articulate my position, because there are a number of other things that I think are more like bread and butter matters, but they need addressing. So, first things first, the provisions that deal with, so Section 2, for example, the definition of data controllers and data processors. To my mind, simply by using the word person, it remains unnecessarily vague. And especially to the extent that this bill purports to capture data controllers and processors who are also governmental agencies and so on, simply using person as the definition of a data controller or processor, to my mind, it may arguably miss the mark. And so my suggestion is that we actually spell it out. Don't leave it up to chance. Say a data controller is a person or a corporate entity or a governmental entity, etc. If we go beyond that quickly, Section 4.1, which is sort of like the foundational section of the entire bill, because that outlines the actual fundamental principles that data controllers and processors will have to abide by. It requires the use of the word "and" in there somewhere, because you have to abide by all of these obligations. And so at some point, perhaps before at the end of the second to last, the penultimate provision, there needs to be an "and" in there, so it's clear that you have to comply with all of them as opposed to cherry picking one and going, well, I'm transparent, but the whole data minimization thing, I didn't do that. And if you keep it going along those lines, Another major one which needs to be addressed is section 5, subsection 3 and 4. So that has to do with the whole question of fairness, ma'am. And so the idea is if you are being fair in how you collect data, then one of your obligations is to, at a very minimum, tell the person you're collecting the data from that here's what I'm doing with it, here's who I'm going to share it with, here's how I plan to store it, here's how I plan to process it, that kind of a thing. So those matters are outlined in subsections 3 and 4 of section 5. But the problem is, when you read through the Act, you realize that essentially the same provisions, but in far greater detail, are outlined at sections, I believe, 18 and 19. So, in other words, we're basically repeating ourselves, and to no good purpose. And especially in a context where this Act will be used not just by lawyers, but lots of everyday business persons. You've seen lots of the persons who presented already are business people, small businesses and so on. They're going to be reading this Act themselves. And so I think it's upon us to be as clear as possible about what it is we're doing and what the obligations are and so on. And
Thank you for your submission.
Yes. Thank you very much for having me, ma'am.
I am going to ask Ms. Bell to speak to a couple things because I think it's important that we have clarification as we go into our questions and answer session. There was the question of the definition of the data controller and the data processor and whether there's a legal person as well as a human person, etc. Can you speak to that, number one? And then I'll the second one after that.
Chair, through you. So when the use of the word person is used in legislation, well, at least our legislation, it contemplates the inclusion of the individual as well as legal persons, so that there would be no need then to specify company or other entity that has corporate personnel or legal personality. So from that point of view, you can take what you can.
Okay. There was also the reference to a consensual audit process preceding the need to go for warrants, etc. I wondered whether or not you wish to comment on that at this stage, or you may defer and we can come back later.
Madam Chair, if we can defer so I can look more closely. Or maybe I need clarification in
Yes.
relation to what you mean by that, sorry.
Okay. You need that clarification now?
Chair, through you, if it is that in your written presentation, if you are planning to submit, then you can write it out so that I can see what you mean by it. Yeah, that would be appreciated.
Very well. Very well.
All right, I'll open the floor to the rest of the committee to ask any questions at this stage.
Sorry, before you do, my apologies and good morning to everyone. And I really enjoyed what I heard of what you had to say. So I'm
Thank you,
really
ma'am.
looking forward to this engagement.
Thank you, Senator Husbands. And Senator Driggs?
Yes, Madam Chair, thank you. This is not, sorry, first of all, Mr. Morgan, thank you very much for your presentation. I thought it was quite insightful. You made some interesting points as it relates to where the legislation lacks clarity on some issues. And one of those things that I want to ask you and possibly put it out to the committee is we keep hearing this issue of one discrepancy between possibly the size of the company, the revenue it makes, and the potential for the penalties that it could incur if you find yourself in that situation. And now on the other side of the coin, we're hearing there's no provision for the compensation for data subjects if you find yourself in a breach, and there needs to be some compensation as it relates to to your data being used without your consent or however that may come about. And I'm wondering if at any point, as we revise the legislation, and this is just to table it, if we can seriously look into having a part of this legislation that is reflective of those two elements, where there's some representation as it relates to the size of companies, if you find yourself in a situation, and as it relates to data subjects and their compensation, and the two of those areas being aligned so that there's some fairness in the proceedings in the legislation. So I just wanted to table that comment for the committee.
So,
If you wish to,
if I may just
Response?
make a comment on that. So a part of why I chose to come here in a personal capacity is I wear a number of different hats, which on the face of it, to an onlooker may seem to conflict. And so I didn't want to take on this process, sort of carrying a brief, as they say. And I attempted to look at the legislation just for what it is and what it is we are purporting to bring about in Barbados. And the reality of it is, regardless of how you frame it, either businesses and perhaps larger businesses are going to be displeased, or smaller businesses are going to be displeased. And then in the third sector, the data subjects are going to be displeased. So you're not going to have any sort of ideal sort of balancing act, especially as regards the whole idea of which obligations you ought to comply with and so on. But to my mind, they said usually the best place to start is the beginning. What are we trying to do? We are trying to secure the data-related rights of everyday Barbadians. If that's the objective, then it stands to reason that a small business, by our standard definitions, who is processing lots of personal data should not get an exemption, because there is no rule in the black hat hacker world that says we don't target small businesses with lots of valuable information. And so if the risk that we're guarding against is data of Barbadians, the personal data being misused, abused, and so on, then to my mind, necessarily tackling it head on from the perspective of, well, big companies get big fines, smaller entities get small fines, may not be the best way, certainly not in the legislation itself. What I would suggest is that on the face of it, I mean, as Ms. Bell would have pointed out, there's a built-in discretion with a lot of these penalties. And so I have to believe that a fair-minded judicial officer, a court, even the data commissioner, when he's given his administrative penalties, he would have to be mindful of the circumstances of the breach. And so if you're a large company, you've already breached this act 2 times, and you're still doing the wrong thing, and it just so happens that you're hacked again, and maybe you're a major insurance company, for example, just making something up, and thousands of Barbadians' data is exposed, then you probably deserve a larger penalty, closer to the $500,000. But you're a small entity. Oh, and this actually brings me to the other thing, which I think is significant. The bill doesn't seem to allow for reprimands. It can't be that our only approach to getting people to do the right thing is to slap them with a big fine. If you committed a fairly mild breach, then surely a reprimand ought to be enough. But perhaps I'm misreading it, but I'm not seeing in this draft where the data commissioner has the power to reprimand someone, because that may be appropriate in the cases of smaller perceived breaches.
okay. I believe that the time is up.
Yes, ma'am.
Okay, I am going to extend because I see that.
Thank you, Madam Chair, and thank you for your presentation.
Thank you, sir.
Very insightful. Now, much of the legislation considered by the Parliament of Barbados in both houses recently has been in a hurried context with the intention of coming into conformity, compliance with international obligations. You made a reference to this.
Yes.
Relative to the EPA.
Yes, sir.
Define for me or describe for me the level of urgency which, in your opinion, now attaches to this, since you said it is a past due obligation.
Yes.
How urgent then, what is the level of urgency attaching to, or is there a level of urgency to it?
4 years. And by that I mean, the particular article of the EPA mandated that we put legislation in place 7 years after signing on to the EPA. We signed on in 2008, so it means therefore that 7 years hence would have brought us to 2015. And so it means we're 4 years out on the face of it. And so there's that. But to my mind, that ought not be the only basis for urgency in getting it done. I remember 2 years ago, I don't know if the committee remembers, when The Economist published a report 2 years ago that said that data is now the most valuable resource. It's no longer oil. Data is the most valuable resource. And so that in and of itself, I think, is sufficient reason for us to get about the business of getting this passed quickly, in a fair manner.
Thank you very much. I'd like to mention at this time as well, it is not simply catching up with our obligations. Barbados has certainly set itself on a path towards digital transformation, and even as we seek to implement the kiosk at the airport, we are recognizing that there is some urgency in us ensuring that this legislation gets in place, because it facilitates the exchange of information with some of our partners in the EU and other places. And so it is not just what we're playing catch up with, it is also what we need to accelerate towards in order to facilitate the transformation that we're seeking to bring on a digital level. So thank you.
I'm most grateful to the committee, ma'am.
I see there's one more comment from Ms. Bell, and I will permit, because I think we have to be flexible at this time when people have meaningful contributions to make.
Just to speak to the lack of reprimand mechanism. Now, the enforcement notice gives the opportunity for the commissioner to state his reasons for asking the data processor or the data controller to do something or to refrain from doing something. But it's the mechanism of reprimand you are thinking of, in a reprimand in and of itself, in the league of perhaps where you would be looking at like the recent juvenile justice legislation type setups, where the judge will be saying, and you should do so and so because so and so is wrong, etc., for rehabilitation or some other type contemplation.
Yes. So as I conceptualize it, it's really a sort of light touch. So in other words, to clarify the whole thing of, well, what the enforcement notice encompasses and so on, the enforcement notice is towards an end which is specified, which is, a fine, administrative fine, drag it before the courts, that kind of a thing. And so to my mind, the reprimand is, as I would call it, a light touch, where you're simply saying, this is the end result. This is what you get for that breach. Slap on the wrist, essentially, but simply saying, you've done this thing wrong, refrain from doing this thing, full stop, but without any further recourse, so to speak. So it would be an end in and of itself.
Thank you very much. Sir, I would wish to request that you make that written submission as soon as possible. In fact, the deadline is tomorrow, if possible.
Yes, ma'am.
And I believe that was communicated in the press as well.
Yes.
I would... and to inform you as well as the other presenters that there may be some things that we were not responding to immediately. It is important for you to know that there being no written submissions ahead, we will take the opportunity for those critical and substantive matters to be dealt with in matters arising at the next sit-in of this committee.
Thank you, ma'am.
Thank you.
Thank you to the committee for having me.
Colleagues, I have just been informed that the final presenter for today has informed that she will no longer be presenting. And that said, I'm going to ask your permission to alter procedure as we would have established, where we said we would do all oral presentations in the morning, then we would break for lunch and come back to consider the written. I will ask your indulgence to take a suspension for approximately 15 minutes, and then come back and do at least the first of the written submissions before we break for lunch. With your indulgence, can we make that alteration in the procedures for today? I'd like to invite a motion, please, so that we can formalize this.
Motion, Madam Chair, that the agenda be amended as proposed and that we break as suggested.
Thank you. We will return at 5 after 12 to consider the first of the written submissions. Okay, committee, I would like to call this meeting to order after our suspension. And just to let you know how we intend to proceed at this time. We will consider the written submissions in the order in which they would have been sent to you by Parliament, which would have been quid guest first, Antonio Hollingsworth next, Shireen Flan next, Shannon, and then Solutions Barbados. Shannon Clark and then Solutions Barbados. So we'll just do them in that order. Pardon me? Yes, Mr. Copper, you seem to have a comment. Okay. Could one of the clerks from the clerk? Yes. Yes. Clerk will help assist you. All right. And that is because you would have been added after, so our apologies to you, and the clerk will take care of it. All right. The intention is that we will look at, I'm assuming everyone has read at this stage. This, by the way, is a closed session in that it is not being streamed. This is just, and the recordings is simply for Hansard purposes. The intention is to go through the critical recommendations in each one and then have a discussion around them and then determine how, if at all, we would wish for it to impact the bill. Is that a fair way to proceed, committee? Yes? Good. All right, the first one is from Soledad Gonzalez, which is Quid Guest, I believe is the name of that company.